position is ascertained as per the existing year in the January. 262 plus 28.
No, what is the argument on this?
Saying that,
There is no dispute of number of vacancies.
it's not that, Lord. The prevailing position with JTET candidates have been ascertained, and therefore, the vacancies which are requirements are provided.
No, this rule, you say, determines the availability of JTT teachers?
No, I'm saying that these were the number of vacancies which are ascertained.
Vacancies only.
Yes, it's pointing out
Madam,
vacancies. I'm
then
pointing out there are.
That has nothing to do with this.
Balaji, yesterday the question was, in the advertisement, it was specified that the person possessing the eligibility on the last date of submission of the selection,
Yeah,
they should be allowed to participate.
that's our submission.
So, madam, please, what was the question put yesterday?
Yes.
The question was, suppose you put this condition in the advertisement.
Yes.
Whether this condition of the advertisement finds support from some rule.
There's no rule per se on
Ma'am.
that.
We asked this question.
We will verify and come back, we have verified. There is nothing in the rule which says the date of advertisement you should possess qualification. That is not mentioned per se in the act, in the rules itself.
All right, that is answer.
Yes.
Otherwise, this issue, this argument is have no relevance.
Very-
This argument was already notified. Another thing is 2016, no selection process took place.
Yes.
So now it took place by virtue of an advertisement of 2023. So meaning thereby, whatever the existing vacancies would be there, that would have been notified. So this argument is having no relevance.
That's all I wanted to say. And Lord, actually this district wise, there is a person with a qualified district.
That you have already advertisement. We have seen the advertisement only.
Okay. And pertinently, there is no challenge to the rules or the advertisement.
That you
There
have
is no
said.
extension.
That argument you have already advanced.
Yes, just one more thing, Even, just one thing, when a vacancy position is ascertained and the advertisement is issued under certain rules, that's my next submission. Existing on the date, mandatory qualification cannot be changed after the selection process has begun is my submission. I will make it good by one more judgment. And I will.
No, that is all right.
Yes.
Selection process have been started. That is the law, we can understand.
Yes.
But here, what is the situation? The
Yes.
selection process was not when, what would be the point of starting of selection process?
To issue the.
Would it be of advertisement?
Yes.
So please clarify this.
Yes.
The starting of the selection process would be from the date of issuance of the advertisement.
Yes, my lord.
Please clarify this.
I am saying, I am making a statement, selection process will be from the date of the advertisement.
Please support by the law judgment.
Very well.
Make it good.
I will make it good, Just one judgment in this, This is a very settled proposition and just one of those judgments which I would place before your lordship's, This is a recent judgment in Assam Public Service Commission and others versus Pranjal Kumar Sharma and others, 2020, volume 20 SCC 680, which is at 33 which is at
29 to 34.
No, Lord, just it is beginning at 29.
Yes,
Yes.
29.
Begins at 29.
Yes.
Not my basis of this argument will be, in this case, the writ petition was filed by them on 18th May. First counter of the state was filed on 25th of June. Pertinently, advertisement was published on 19th of July. Thereafter, state filed a supplementary counter affidavit on 14th of August, sticking to its stand that they cannot include CTET. and the impugned order was passed on 20th of December. The rules amended subsequently.
That's
on
a different thing. You were to cite a judgment on the issue that starting point of
the
class.
facts will have a bearing. Therefore, I was just recalling this aspect of this factual aspect. Then we not kindly come to the judgment. 2020, volume 20, SCC 680.
Which
Please,
paragraph?
paragraph 15 to 20. At page 33.
Yes.
Here, my lord, when the selection started based on a particular rule, it was amended in midway.
Where you are reading?
Paragraph 15, I am just going to read. The
Read.
law with regard to applicability of the rules which are brought anew during the selection process have been crystallized by this court. It has been held that the norms existing on the date when the process of selection begins will control the selection, and alternation to the norms would not affect the ongoing process unless the new rules are to be given retrospective effect. This is mentioned in State of Bihar versus Mithilesh Kumar. Similarly, in Devin Katti versus Karnataka Public Service Commission, this court held that a candidate has a limited right of being considered for selection in accordance with the rules as they existed on the date of advertisement, and he cannot be deprived of that limited right by amendment of the rules during the pendency of the selection, unless the rules are to be applied retrospectively. If we proceed with the enunciation, the conclusion is inevitable that for the current recruitment for which advertisement was issued on 21/12/18, the 2019 procedure can have no application, which came into force on 1/4/2019, can have no application, particularly when the first phase of selection, that is a screening test, was conducted under the 2010 rules. One must also be conscious of the saving clause, etc., etc. This is the main paragraph, 1516. So, my lord, I am submitting that, not the interest. Finally, my lord, here, after everything is over, after last date was over, this amendment comes and the date of extension comes only because of the impugned order. Now, my lord, we are challenging the impugned order as such on several other grounds. The interest and welfare of the children are also to be considered, my lord. The act itself, the RT is itself a child-centric enactment. This court has held so, my lord. The relaxation in the manner in which granted by the Honorable High Court by way of the judgment will amount to rewriting the act and the advertisement.
How interest of the children is coming in
Yes,
this?
Lord. Because
Any teacher appointed, there will all be eligibility is the issue.
no, that's not the point, my lord. In formative years, the children coming from various rural backgrounds, not
Yes.
in a state like
Yes,
Jharkhand,
yes,
they are
yes.
coming from a very different backgrounds,
And
and most of them tribals, Lord. So therefore, Lord, they look for candidates who pass or qualify in a particular language for a particular.
that you have already argued.
No, therefore, I am just submitting in the conclusion that this has to be kept in mind, not that when we are dealing with the RTE. Therefore, Devesh Sharma judgment will be of use on relevance here. That it says not the yeah. They are now telling me not the practical angle. I will tell you also. They are now saying, okay, you take them CTET. In 3 years, you conduct a TET. If they qualify,
That they have mentioned.
if they don't qualify, interest of children for the 3 years, whatever they knew. That's all. Then that angle has to be kept in mind. Why not they write the TET, JTET, and then not qualify and then come to this when we are already available in the frame. So therefore, we not after 3 years to test whether this candidate will be suitable or not will be.
Will consider any.
Yes, not. So therefore, I will just seek your lordship to see Devesh Sharma. Will only mention para numbers, not. It's in the compilation also. 2023 SEC online 985.
Which para you want?
Paras I will mention, not 12, 22. 30, 31 to 33, 63 and 64.
12 is
12, 22, 30, 31 to 33, sorry,
31 to 33,
63,
63.
and 64.
What is the nutshell ratio of this?
In this law, teachers of likewise in that earlier judgment, B.Ed people were considered by the state for the primary school. Then when the qualification is DL.Ed, that is Diploma in Elementary Education. So the court said, even if you are qualified in B.Ed, looking at the
The
primary.
higher qualification, that judgment you have already referred
It's
to.
not only for higher, Milord, it's, they look at the pedagogy and the children, how they have
Yes,
been
yes,
taught by these
Yes,
people.
yes, B.Ed people can't teach the elementary class. That's right.
Your contention by referring this is when DL ed is prescribed, then having purchasing the B.Ed may not be of any importance because there is a purpose for DL and that is connected with the primary education. So that was the importance. And once JTET have been prescribed here, specifying this language itself
Yes, ma'am.
and the other territories and area peculiarity of that,
Yes,
then in that situation,
yes,
JTET cannot be superseded
yes, Milord.
by the either by CTT
Yes,
or by TET.
yes, Milord. And
That
by,
is all.
that's all, I'm deeply obliged. And in fact, in the other case, the selection was over, which was set aside, in Lata.
What is this anti?
Just the advertisement.
What is this anti Devan Katti? You have referred this
Yes,
one.
Milord. Devin Katti will be, Milord, 1993 SCC 1.
This is on which point?
43, page 43 has it.
What is the?
Which point?
Same point, Milord. The point which I referred in 2020. This is about, not, you have to only go by.
Amendment. The
After
advertisement issue.
advertisement, subsequent amendment. Here also advertisement. Pursuant to when advertisement is issued, your lordship's question is also answered, Devin Katti. Advertisement will be the starting point. So your lordship said, please make it good. Not Devin Katti says so, where advertisement is issued, inviting applications for direct recruitment. Advertisement expressly states the selection shall be made in accordance with the existing rules. If it further indicates extents of reservations in favor of various categories, selection must be made in accordance with the then existing rules. That's our submission.
All right.
Deeply obliged. Can I, just in case I may have to go in between.
Yes, yes.
You can.
I'm here, Lord, as
We are only concerned with your argument you have argued. Then your
I would like.
colleagues may
Actually,
look into.
I would like to be.
Any other
Colleagues may
petition?
look into.
I'm deeply obliged.
All right. Yes.
Lord, the submissions which I
Any-
have prepared, can I just pass it on? Lord?
Yes, please give it. We are interested.
I'll
in
just give it to, give. Yeah, give the 4 copies. Yes, please. Anything you want to say?
Anyone else to this side? Now come to Bihar. Come to Bihar. Wait.
Bihar case also is there.
Yes, I am appearing for.
Come.
Lord, in Bihar, the Bihar State pass candidate has filed a writ petition before the High Court for
Who filed the writ petition in Bihar?
Bihar State pass candidate, BTET.
PTET.
BTET, yes, Lord.
Okay.
They filed the writ petition before the High Court
Hmm.
for questioning the section 5(1)(a) of the Bihar Panchayat Primary School Teacher Employment and Service Condition Rule
Hmm.
2012, my lord.
What was that rule?
The rule was that the seated pass candidate has been allowed for the appointment of the
Seated pass
primary
means?
school teacher.
Seated pass means?
Seated means Central Test Eligibility
Oh,
Test.
CTET.
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 Don't say PTET and CTET.
Yes,
What they say, CTET is allowed
yes, my lord.
by virtue of a rule.
By virtue of the rule, my lord.
Hmm.
BTET pass candidate has challenged that rule, my lord.
Hmm.
That particular section 5(1) for my lord.
Which page is
The-
that section?
Section is on page number
Kindly read
75.
kindly read that rule, please.
Yes, my lord. 75.
75.
Yes,
What is this document you are reading?
it is the rule, my lord.
For teaching in middle school. Where is primary?
Elementary.
The
Minimum eligibility
relevant
employment.
portion is on page number 75, my lord.
Just a minute.
Starts from 73, relevant portion.
Just a
Put up the page, my lord. Page number 73. Para number 5.
73.
Yes, ma'am.
Para number 5 or rule number 5? This would be rule, na?
It's a-
Minimum
Yeah,
eligibility.
rule, but it's a section 5, section.
Section, para, rule.
How in the rule sections can be there?
Sorry, my lord, I'm sorry.
Act includes sections.
See,
In the rule sections are there.
Rules cannot be sections. Para may be there. All right. Come, rule 5.
it's a clause, my lord, I'm sorry. It's a clause.
All right,
five.
clause, whatever it is.
Clause, no?
You go ahead, go ahead.
One clause, my lord.
Very good.
This is a type copy.
Yes, my lord, it's a type copy.
You must have a notification, na? State government notification.
It is not on report, but it is mentioned in the impugned order.
You would have, na?
Yes,
From that you would have typed, na?
yes, my lord.
Please give that rules of notified rules. We are concerned with those notified rules.
I have not, right now, I have not.
Give it, supply it later.
Yes, my lord, I will supply.
Please make your submission.
Yes. Kindly see clause 5, my lord.
Yes,
Minimum eligibility for the employment, my lord, for teaching in primary and middle school, my lord. Class 1 to 5 basic grade of panchayat and block teacher. Then these are the higher secondary with minimum 50% marks or its equivalent and 2 years training, elementary education, science, none by so and so. And then similar qualification. Then the relevant portion is next page on page number B, my lord.
and
Number?
Clause number 5B, qualified on page number 75. On page number 75, my lord.
yes, please. Qualified in teacher eligibility test
Test
held
held
by central government
government or the government.
or the government of Bihar.
Yes, my lord. So we
So
have challenged that.
So in the rule, it is mentioned
Yes, my lord.
that CTET is permissible.
Permissible, yes, my lord.
All right, yes. Then for the purpose of middle school, similarly, in clause B,
Yes,
all right,
yes, my lord. On page
that you want qualified teacher test held by central government or by the government.
government of the Bihar.
You challenge this.
Yes, my lord. We have challenged.
All right, what was the ground of challenge?
Ground of challenge, my lord, that the notification of the NCTE and the definition given in the section 2A, my lord.
Please come concisely
Yes, my lord.
where you have taken this ground in your writ petition. Please come directly or concisely this ground you have taken in the writ petition and what is the reply of them and how it has been dealt with by the High Court. These 3 things please apply.
Yes, kindly see page number W, my lord. In the list of dates, it's mentioned.
It
We
will
are
not be
asking
the
them that
writ petition.
Please, we are unable to
Writ
understand
petition is
that
not.
whatever you write in A, B, C, D, W, Z, we
Yeah.
are not interested in that. We are interested what grounds you have taken while challenging the vires of this rule. Then what grounds you set out in your writ petition, please show us
My lord,
that much.
my lord, I'm sorry, my lord, writ petition is not on.
It said you file it, then we'll consider your case.
I'll
Later.
file, my lord. Time.
File it.
My lord, I will file it, my lord.
देखिए इसमें लिख दीजिए the petitioner counsel prays for time to file the pleadings of the writ petition and the counter affidavit filed by the state of Bihar. Full stop. It will be done within
Permission may be given to file the rejoinder also, my lord.
4 weeks. 4 weeks कर दीजिए इसको.
My lord, permission may be given to
4
file the
weeks.
rejoinder also, my lord.
क्या लेगा उसको rejoinder की जरूरत नहीं है. तो ये लिखिए counsel for the petitioner prays for time to file rejoinder attaching the writ petition, pleadings of the writ petition and the counter affidavit and other material documents filed which is not on record in the writ petition.
Online.
Yes,
If
please.
I may, just a few minutes. That note you wanted, I've updated the note if that can be
Give
taken.
it, give it.
Give the officer.
Detect. लिख दीजिए.
Well, based on this,
इसको challenge करने का हूँ, अब वहाँ से लेना पड़ा. Yes.
the first, my lords, your lordships had asked about the syllabus for the TET and what they have to go through. So that if from this same note, my lords, if your lordships come, this is funny. This is the same one. At the first page, bottom, last line.
Yes, please.
Rule 7D and E is pattern of the exam, my lords. That's at page 27 of the counter.
Yes.
Next page, top, rule 7J, third item, 7J,
Hmm.
second page.
Syllabus will be as per schedule.
Schedules 2 and 3, that's at page 28. And the schedules 2 and 3 are at page 32 and page 33 of the counter.
Hmm.
This is just to respond to yesterday's question.
Hmm.
Today's question, which you put to Ms. Mona, my lords.
No, here we'll come to that.
No, I just want to give the citation.
No, we are asking a different.
You are not replying to what she said.
Sorry,
Mr.
I didn't.
Gopal Shankar
No,
Narayan,
no, sorry.
you are very fast.
No,
We are not that much fast.
no.
Absolutely fine.
Yes,
This is specified in that rules of the TET,
yes,
JTET of Bihar.
correct.
Please compare this JTET
Yes.
with CTET.
Yes,
CTET,
Yeah.
what is prescribed in CTET.
yes,
Syllabus.
yes.
So we can understand the curriculum of CTET and the curriculum of the JTET, that is different curriculum.
So do they have it on record? So the CTET.
So we are not going fast very.
No,
We
no,
want to understand ourselves.
I will explain. Now the CTET syllabus has not been placed on record. I have it here. It mentions exactly 20 languages, which are the scheduled languages under the Constitution. And it says select 2 languages in which you appear for CTET. List of languages offered with their codes as follows. This is not on record. I'll place it on record, but this is the CTET, those 20 languages. Under the Jtet, as your lordships have seen yesterday, we pointed out, it's there in these pages itself. Rule 7I, the second entry, just above 7J, page 2 of the note.
We want to see these languages,
Yes.
these rules.
Page 28 of the counter. Manoj.
Counter देना जरा इनका. In the first case counter,
Yes, Manoj. First case counter.
we want to look into this
Yes,
because this may have some relevance.
absolutely. I'll take a look.
So you
So,
come to rule 7,
yes,
page number 26.
yes, Manoj. That's where it starts.
Page 26, please.
26, bottom is 7, the format of the teacher, your lordship have.
Will be as follows.
Will be as follows. I will read the whole thing because it's relevant.
Please kindly read.
Yes, there will be 2 levels of eligibility test, that is primary school and higher primary level, and the candidate will
What do you mean by higher primary? Middle,
6 to 8.
6 to 8.
1 to 5 is primary, 6 to 8 is higher.
All right.
So there will be 2 levels, primary and higher primary, and the candidate will be able to appear in both the level examination. Primary is 1 to 5, higher primary is 6 to 8. Each level of examination will have a consolidated question paper, duration of which will be as follows: 2 hours, 30 minutes, 3 hours. For visually impaired, additional time of 30 minutes. The exam will be a multiple choice. There will be no negative marking. Pattern of the tests are given, which is this is in accordance with the rules. Child development and teaching methods, multiple choice, 20 marks. Language 1, assistant teacher, Hindi and English. For Hindi, 20 questions, English 20 questions. Urdu, assistant teacher, Urdu and English. Then language 2, which is regional or tribal language. This has as much as 20 marks, Malod, which is regional or tribal language. So it is not the 20 languages which are in the Ctet syllabus. These are separate. It's in the schedule.
There also the test is for all 20 languages? Sure.
No. You have to choose 2.
Then,
You have to choose 2.
then here also is a choice.
Yes, but because it's Jharkhand, the
Yes,
languages are different, and I'll show you.
That we'll see.
Yes.
Whether the languages are similar or.
Your argument, we can understand
Yes.
that 2 regional public travel language.
Yes.
And what is the wording we have to compare with the CTET to that effect?
That
So therefore, we were asking that much.
that just show me CTET. We're getting printouts of the CTET.
You please give the printout.
I'll give you.
Then we'll look into.
I'll give you.
CTET is there somewhere, otherwise we'll look into here.
It's not on record, to be fair. I'll give you a lordship's that.
All right, fine. Come to the next.
Then below that, Manoj, is the pattern of eligibility test for classes 6 to 8, similar in nature. Only that from 20 marks, language 2 becomes 25 marks.
Okay.
That's small Roman 3.
Language is still language 2, regional tribal language.
Regional
with
tribal with
Sanskrit.
Sanskrit. So, but
So
earlier one,
here it is one added,
yes,
this is Sanskrit,
Great.
Sanskrit.
alright,
Yes.
two regional
Yeah.
travel language with Sanskrit,
With Sanskrit. So
alright, 25 marks,
25. Yes.
alright,
Then page 28, my lord.
28.
Yes. The question papers will be in both Hindi and English languages, and the medium of examination will be Hindi or English. The question papers of other language subjects will be in the respective language, if you choose another language.
The question paper of the eligibility at the primary school level will be based on the syllabus of 11.
Yes, I'm sorry. Will be based on the syllabus of class 11 and 12 under NCERT, CBSE, and syllabus approved by state government. Maximum level of difficulty will be 10 +2, higher secondary or equivalent. Questions of eligibility test for higher primary will be based on syllabus of class graduation under syllabus approved by UGC.
That is not relevant.
That's not relevant. Regional and tribal language mentioned under language 2 in rule 7, D and E, which your lordship saw, will be as per schedule 1 of the rules. If I can take your lordship right away to schedule 1, that is
Yes.
page 31.
Page 31.
Yes.
Yes.
Get the CPE. Yes. District-wise list of tribal regional languages under Jharkhand Elementary School Teacher Appointment Rules 2018. Your lordship will see against each district, the languages are there. Kudak and Santali are the most prominent ones, but there are others as well, district-wise. There's the district-wise tribal language and the district-wise regional language separately. So the regional language, your lordship can see Nagpuri, Kurmali, etc. Khorda. So all of this is absent in CTET. It doesn't even feature. These are the 24 which are in schedule 1, for which 20 marks weightage in 1 to
Suppose
5.
we look
Yes.
into this rule,
Yes.
then if we find
Yes.
that the pattern of the test would be like this. In this pattern,
Yes.
in subjects, this language, regional or tribal language,
Yes.
we accept regional / tribal.
Yes.
So what would be meaning? He may take a regional / tribal, or he is required to opt regional and one tribal. It is not clear.
I just see I at page 28.
28.
Back to the rule, Manoj, rule 7I, where we just departed from, where it referred to languages in schedule 1. Next sentence. For appointment to the post of teacher, the candidate will have to take the examination in any one of the regional / tribal languages allowed for the district applied. In the regional /
Their applications are also for particular district.
yes, particular district. The lordship saw yesterday with the advertisement, they had for para teachers, they'd given.
That is there.
Yeah.
But whether the advertisement mentions that you are applying for a particular district,
It does so.
or it is a general 23,000 posts, so you apply for all of them.
It says so. No.
Is there an option in there that you are applying for district ABCD?
Just give me half a minute. I just have to verify. Just in the main advertisement. I'll give you a wrong answer. I'll just verify
You will come back.
on advertisement. Yes.
Suppose we read this
Yes.
I,
Yes.
we read with simultaneously.
Yes.
The intent of rule I is
Yes.
regional and tribal language mentioned in language 2
Yes.
in rule 7, D and E. Rule 7, D and E both
Yes. That's language 2.
will be as per schedule 1.
Yes.
So what may be a regional or tribal language that would be as per schedule 1.
Yes.
Now, here 11.
Yes.
For appointment to the post of teacher,
Correct.
the candidate will have to take examination
Yes.
in any one of the regional tribal language allowed for the district applied.
Correct.
Mistake applied is.
So implication
District
is
applied
Yeah.
means
that the application.
you would have applied for a particular district,
Correct.
and in that district,
Yes,
if you applied,
I'm limited.
then, then in the CTET pattern,
Yes,
you must have passed this
correct,
examination.
correct.
of
This
that.
needed to be done. Yes,
But here there is a difference.
yes,
This rule
yes.
is which rule? This is the
Rule
rule
7,
for,
it will be under 7.
this is rule for TET.
Yes, for TT.
All right,
For the
means
J-
whatever you are taking in the TET,
Yes,
all right.
yes.
And as per that TET rules, what is the curriculum and how you have to opt for the languages.
That is correct.
So in that situation, you should have passed it out JTET.
Yes,
So in the JTET mark sheet, can you put an example
yes,
that in any of the mark sheets of 1 or 2,
yes.
that this is the language which you passed out, and accordingly, this is 1, and the second is, please, second is
Yes,
which we are asking the answer,
yes,
have you applied
yes,
for the district? And your appointment, if we look into,
yes.
all right, this is not the recruitment rules.
No, no, it's not. It's the
This is
Jtet rules.
Jtet rules.
Correct,
So this is for Jtet, means for qualifying the Jtet.
correct, correct.
Is it any relevance of this
Yes.
in the recruitment rule?
Because statutorily.
No, please.
Yes, I'm sorry. Yes.
Please, please.
Yes,
We have two different things because we are testifying the what proposition in the context of this,
yes,
with the recruitment rules.
correct.
So in the context of this, is it any something prescribed
Yes,
in the recruitment rules by which they have to apply for the district wise or something? So you have to please compare this and answer.
very well.
Is it necessary? This is necessary.
Yes,
This appears to be necessary.
yes. So I have extracted for your lordship's convenience in page, sorry. So.
We are able to convey you. what
No,
we
no,
want.
absolutely, your lordship must.
We are able to convey you.
So 3 questions your lordships have put to me. I'm just making sure that I've got it right. The first question was with reference to the stipulation in the advertisement that you must apply district wise. I have to get back to you on that. The second point was,
Not
please give an
really.
illustration of one.
Please, not only in the advertisement,
Yes,
it must be supported by rule.
correct. So that was the third point I was coming to, which you just made. The second point is give an illustration of any one candidate, perhaps the application, which will show that the selection of the language has been district wise. The third question now is that, is there a reference as far as Jtet is concerned, and particularly district wise applications in the applicable service rules of 22? Those are 3.
Because that is there, every answer would be there.
Correct, correct.
Then Mr. Maninder Singh, maybe it would be a tough question to Mr. Maninder Singh.
But I'm hoping so.
We are having divided burden.
No, no, we have nothing. We are not asking Mr. Maninder Singh.
We
why
have,
you
we
are
had
so
seen the double barrel gun yesterday.
Huh?
Not doing that.
But Mr. Gopal Shankar Narayan,
Yes,
another issue may not be in this case, but just need to understand.
yes,
Now, schedule 1 says tribal, regional.
yes,
Both are different,
yes, there is.
right?
Yes,
Your rule 7 clause I says
1.
that it has to be taken one, either regional or tribal,
Yes, that's my understanding. Yes,
and for the district applied.
yes,
Now, if somebody has taken the regional language,
yes,
he is eligible to apply in that district.
yes.
He doesn't know the tribal language there.
He doesn't.
What is the use of his appointment there?
This is a pedagogic question, which is policy wise. Your lordships are right. This is not a question really I can
No,
answer.
but otherwise this issue is there now.
My understanding is that if you have one or the other, and I'm not familiar with Jharkhand, I'm presuming that those who have laid down these stipulations have felt one or the other
But
alternative.
we don't accept this argument because the council and Supreme Court are expert of the entire state,
Not me,
entire country.
not me, not me. That may be true of others. I'm an expert in nothing.
Presumption and law.
Presumption. Well, in fact also.
In fact, Guru knows me very well to know that this is not true about me at all.
No, no, Guru knows what the other Indian doesn't know. And what would,
unfortunately, but he will keep it to himself.
Yes, please go ahead.
But if your lordship sees, I was just continuing on this. I was at I. In the second part of I, in the regional tribal language test, the candidates will be expected to have knowledge of the concerned language and its grammar, and they can express themselves accurately in that language. The syllabus for primary schools, this is J, and higher primary schools will be as per Schedule 2 and Schedule 3 respectively. I can take your lordships immediately to Schedule 2, my lords, which is at page 32.
That is not an issue here.
Not an
Issue is language only.
Correct, correct. It is, but
Because other syllabus, they may have whatever is there. We are not going into that detail.
yes, my lord, but I think just if your lordship will see it, because it's for eligibility determination, it makes a reference to language. That's what I'm saying.
No, language is a separate paper altogether.
Correct, correct.
So for that only we are seeing.
Right,
Because you are comparing, this was the argument raised that
yes,
CTET will not have all these languages.
that is correct.
So they should not be eligible.
Correct.
We have the local languages.
Correct.
Now the question is on that only.
Very good.
You have chosen one regional language.
Yes,
You do not know the tribal language in that area.
Yes.
How you will also be eligible?
but I know one of the two, which are required.
One of the two, if it is strictly in tribal area.
No, but it's one of the two as prescribed by the state.
That
As
is there, but how do they justify this? Your argument is little
No, I
dicey on this.
the substantial
We
difference
don't, we
between.
don't understand the import of the rule if that is the object.
No, as per their stipulation.
Yes, it is there.
As per their rules, this is the languages they have put. And they've made it compulsory that you must know these languages and you either 20 marks or 25 marks along
Yes,
with
yes,
the Latin.
That is,
So, now, the next to pass the examinations, they've given the details, my lords, minimum 40%.
that's all right. We are not on that.
No, I'm just for completeness reading the entire rule. That's now. You have Ctet printouts? Ctet printouts, if I can just hand up. We just got it.
Jtet.
I'll just answer each of these questions that your lordship put to me. If I can start with Ctet.
Yes.
Give. Now,
Where is this syllabus in this?
if your lordship so please to come to page
No,
4.
this is, no, this is only information bulletin,
Yes.
not the rules.
No, these are not the rules. No, these are not the rules.
These may change from year to year.
No.
This
You
is the
don't do
latest,
this.
July 24.
These
Don't
may
do this. Come with rules.
I'll get you the rules.
Don't do this.
I'll get it. Only list of languages. I'll get you the rules.
No, in the meantime, till Mr. Marinder Singh and Guru Krishna.
No, I just-
Arora will do.
Just
In the meantime, you can find out.
2-3 supplementary points because
Supplementary
I
points.
want them to be put on notice about what we are saying. I don't want them later to say in rejoinder we are bringing up something. That's all, in fairness. So one is in response to what your lordship asked me about the rules. The page 243, if your lordship will see in the SLP.
243.
Page 243. The rules start at 228.
Yes,
Yes.
243.
This is at the bottom of page 242, last line, says chapter 3, posts and pay scales. 242. The lordships have that?
Post and pay scales.
Yes, posts and pay scale. Now the next sentence, 243. All the posts created district-wise by the state government for smoothly conducting education in primary schools will be under the assistant teacher cadre. That cadre will be district level. It will have the following categories. This is what they say. That will be district level.
Right.
So this is just to respond to that. Now, regarding the one example, my lords, of the TET, we have of one candidate.
Along with that, in the advertisement, whether the application is also invited district wise?
Did you find that application?
Anything mentioned in the advertisement like this?
It's only what we showed your lordships, that the list of
No,
districts.
that is there. It has to be there somewhere that you are applying for district ABCD.
That form we have not annexed, my lords. I'll have to
Not
give you-
form, it must be there in the advertisement only.
The advertisement has an application form separately, which is not on record. So I have to give you the CTET rules and the application form. These two things I'll have to place before your lordship. Right now, it's not on record. If I may, after the other side finishes, I'll give your lordship that. So this, you've given copies? Well, this is of one candidate, Vinita Horo. This is from the Jharkhand Academic Council. Has qualified in the teacher eligibility test for the post of assistant teacher held in the month as detailed below. And language 2 is given as Mundari, which is one of the languages in that list. So this is an example as an illustration. This one we have immediately. Just
Either can, either can,
So you want to convey by this,
yes,
as per chapter 3, post and pay scales,
yes,
it recognizes
yes.
the appointment at district level
District.
and the inference of this district level appointment
Yes.
can be connected with that
Rule 7I and the
7I and J. You want to convey
That's what I want.
your context.
That's what I want to say.
This appears to be.
Yes, that appears to be. Finally, on the law,
And the question is still to be answered is,
CTET.
no,
Yeah, sorry.
CTET is fine, you have to, but my brother has asked,
In the advertisement,
in the
there is a
advertisement,
stipulation.
where
Yes.
there is a stipulation that
Yes.
you should apply
Application will
fixed
be-
stipend.
Yes.
There is that stipulation, or in process of selection, if
Yes.
something had been issued guidelines,
Yes.
thereby in selection, when
Correct.
you will select those persons, then how you will arrange that name of the merit?
Yes.
Would it require to be arranged in accordance with the merit?
Yes.
And if it is so, then how without option can be possible?
I'll respond on that.
This is first question, then answer.
I'll frame that. Now, if your lordship will just take that compilation of judgments that were handed up to your lordship by Miss Mona.
Yes, Mon.
Just the first one, my lords, is Devesh Sharma.
Yes,
Just please come to page 21, my lord.
one of the wish.
This was an SLP arising from a Rajasthan High Court judgment which struck down the NCTE's notification which allowed B.Ed also. They said you can't allow B.Ed also. So para 63, Manoj, at page 21, if I may read that. In Society of Unaided Private Schools, this court while upholding the, I'm sorry, Manoj, Justice Bindal held? Yes. This court while upholding the validity of the RTE Act held that primary education, which is now part of fundamental right under part 3. Constitution has to be a meaningful education and not just a formality. When diploma in elementary education was placed as an essential qualification for teachers in primary school, it was with a purpose, and the purpose was to declare only such teachers as qualified who are trained to impart education to children at primary level. The pedagogy for a child who has just entered the school is an important consideration. A child has come to face a teacher, so to speak, for the first time in a classroom. It is the beginning of a journey for the child student, and therefore, world over, great care is taken in laying down proper foundations in these formative years. Well-qualified and trained teacher in elementary school is an extremely vital aspect. A teacher must be trained to teach students at primary level, and this is precisely what the training of DLED does. It trains a person to teach children at primary level. B.Ed is not a higher qualification or a better qualification as is being canvassed in its favor, while comparing it with diploma in elementary education. If your lordship can skip the next few pages, which are peculiar to the DLED issue. About 4 lines down on page 22. This defeats the very logic. This is about having a 6-month bridge course along with the B.Ed to bridge it. This defeats the very logic of including B.Ed as a qualification, as the very notification which pushes for the inclusion of B.Ed also recognizes its inherent pedagogical weakness in its relation to primary classes. This is precisely what the High Court has done in this case, saying within 6 months, you will have to qualify. It is to cover this defect that all such candidates must undergo a mandatory 6 months bridge course in elementary education, exclamation mark. The irony here is that all this is being done when the state of Rajasthan already has more than the required number of diploma qualified candidates available. This is besides the fact that there is presently no such bridge course available. At least there was none till the disposal of the petition by the Rajasthan High Court. Next paragraph. Under these circumstances, we are unable to comprehend as to what was the pressing need to include B.Ed candidates who are admittedly not fully trained to take up primary classes. Consequently, the decision of the NCT to include B.Ed for teachers in primary school seems arbitrary, unreasonable, etc. I am adopting this reasoning, my lords, for what the High Court has done. Candidates are available, this or not. But again, in that compilation, the last judgment, because your lordship put a question just now about advertisement being the starting point of the selection process. So the last judgment there, my lords, is Devin Katti at
Yes.
page 43, my lords. Just see para 11.
Yes, please.
Para 11. There is yet another aspect of the question where advertisement is issued inviting applications for direct recruitment to a category of posts. And the advertisement expressly states that selection shall be made in accordance with existing rules or government orders. And if it further indicates the extent of reservations in favor of various categories, the selection of candidates in such a case must be made in accordance with the then existing rules and government orders. Candidates who apply and undergo written or viva voce test acquire vested rights for being considered for selection in accordance with the terms and conditions contained in the advertisement, unless the advertisement itself indicates a contrary intention. Generally, a candidate has right to be considered in accordance with the terms and conditions set out in the advertisement, as his right crystallizes on the date of publication of advertisement. However, he has no absolute right in the matter. If the recruitment rules are amended retrospectively during the pendency of selection, in that event, selection must be held in accordance with the amended rules. Admittedly, the rules are not amended retrospectively, the present rule. Whether the rules have retrospective effect or not primarily depends upon the language of the rules and its construction to ascertain the legislative intent. The legislative intent is ascertained either by express provision or by necessary implication. If the amended rules are not retrospective in nature, the selection must be regulated in accordance with the rules and orders which were in force on the date of advertisement. Now, this has been followed recently. This is a 2-judge decision. It's been followed recently, give copy, by a 3-judge decision in ASAP Public Service Commission. This is 2020. I'm sorry, we don't.
This is also on record here.
No, my lords.
It
it's
is
not.
there.
Assam Public.
Serial number 2.
Yes.
Oh, so sorry. You read it? You read it?
Yes, she has already read it.
That's been
Anshul
read.
Kumar Sharma.
So it's been followed for the same, just paras. Paras 15 and 16.
Yes, she has already read that.
So it's been followed, and that's the consistent position. That date of advertisement. One small thing on facts. The date of the advertisement is 19th July 23. Now the advertisement itself gives for the last date of application 7/9/23, and last date for modification of the application is 15/9/23. Even if we were not to take the date of advertisement as when selection process commences, at least the last date
of submission of application.
Last date of modified application 15 September 23. By then, no amended rules had come. Impugned judgment had also not come. Impugned judgment, which is in December, becomes the basis for the January new rules coming. So there was no question really of extending a date once the date is over and done and the process is complete, in my view. So even if it's not date of advertisement, even a later date, it doesn't come by then, and it's not retrospective. I'm grateful.
Thank you. That is all.
We'll respond on those 2 points your lordship mentioned.
We'll find out. Yes, please, Mr. You are for the government.
For the government in the first matter, my lord.
First matter.
Lord Parimal,
There is a difference in 2 matters.
the state will remain the
There
same.
is,
Lord.
no, difference is
Issue is
only,
different.
difference is only the functioning of 2 engines.
Double engine.
Double engine. I don't know, we are trying to make ourselves the engine.
No, double we are not saying intentionally, 2 engines.
Lord,
So that you can understand, we will not explain why 2
yes, my lord.
and what is the purpose.
My lord, but I must confess, my lord, my all colleague, we sat down together, my lord, to prepare a list of dates, my lord, but even with your lordship.
No consensus?
No, my lord, with your lordships, every question today, I pick up the list and see whether there is a date there or not. And I come to know, my lord, that there are two rules, my lord, with which your lordships are dealing. One is the recruitment rule, the other is the TET rule.
TET rule.
So, my lord, every time with the help of, my lord, my friend and my friend here, we are finding that there are so many notifications in both the rules, which have come after filing of counter, etc., or even before that, which are not before your.
We are not interested in
No, only-
after filing of.
Only relevant, my lord, only
We are
relevant.
not interested in after filing of the counter. We are only concerned whatever is prior to that.
Only on that basis, my lord. No, my lord,
And the another question is, what is the, once rule is there, already there. So where is the import of issuance of notification? Is it circular or it is an amendment in the rules?
there is an amendment in the rules.
In the rules. So prior to that, only relevant,
My lord,
not later.
my lord, I have to first of all answer your lordships on the question which have arisen with regard to section 23 of the Act. If your lordship, if I'm able to satisfy on that answer, my lord,
Yes.
then most of the other questions, my lord, in my respectful submission may get answered. Kindly come to 23 straight away.
We will come to that.
Because, my lord, your lordship may just keep two things in mind.
RTA.
Party Act.
There is a TET rules, my lord, first of all, recruitment rules and TET rules.
No, whatever you want, we will see
That,
first.
Lord, I'm only, my respectful submission, there are two rules which are applicable in the
No.
present case, have some play. One is the recruitment rules, other are the TET rules.
No, what is to be seen first?
First of all, the Act.
23.
Yes.
23.
Yes.
So you want to get out this?
No, I want to get into this with clarity, my lord, to myself. I don't want to get out.
You are clear.
Lord, we once enter the portals of the Supreme Court, we never want to get out. And we have the privilege on this side, we can choose a date of commencement or the last date.
Alright.
Both, my lord.
Alright.
Commencement as well as, kindly come to 23 straight away. My lord, your lordship have seen the,
And application of rules as per your choice.
which, my lord, will be decided by your lordship.
In the context you are saying.
Yes, my lord, in the context, unless the context otherwise requires, my lord. Now, my lord, your lordship has seen the definition of school as well as the appropriate government, your lordship.
So by this time, you did 20% rule. Right? Deviating from the thought process which have come from the petitioner side.
Yes,
So 20% rule you have discharged.
But with the gradually you will remind us, no?
Something that just fits with the situation. This is, we have a sort of arguing the matter, what they tried that way. So he said, oh, my client said, oh, we can't pay any money. Other side pointed out, oh, look at this balance sheet. They have so much of money. What are we saying? Listen, that was before they had engaged me.
Now it is plus 10%, 30%.
And rest will be played by Mr. Guru.
All right.
100% flat.
23-1, my lord.
Yes.
Qualification for appointment and terms and condition of service of teachers. My lord, I'm not going into other issues which are not relevant here, my lord. Primary education, higher education, central government gets priority under entry 66, not relevant here.
That's not the issue.
Yeah.
They have not argued it.
I'm not even raising it. This right to education 23-1 and 23-2 and 23-2, my lord, if I am right and persuading your lordship, my lord, the answer is in 23-2, which would resolve a number of issues. Any person possessing such minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. No, so far so good, no problem. Kindly come to 2. There are two extremely relevant nomenclatures in 23-2. And the relaxation qua that vested in the central government is only qua 2, which never includes STET.
All right. Let us.
Where a state does not have adequate institution. Because, my lord, after the NCTE, it is the approval of the NCTE for all those colleges, my lord, who can legitimately and in a recognized manner grant education in the education courses like B.Ed, etc. So NCTE approves all of them. That is the body created under the NCTE Act. They will, my lord, decide what is on what parameters a particular institution impart that education will be recognized. where a state does not have adequate institutions offering courses or training in teacher education. Please mark it, Malad.
TET.
Malad, two things. Offering courses or training. That is neither a course nor a training.
What is neither a course nor a
It
training?
is, I'm going to show it to you.
TET you say is not a course.
It's only Malad, a eligibility test like a CTET. Like a common, it's not exactly common entrance test, the old common entrance test, Malad.
Common entrance test is different.
But that is not a qualification or training. It is neither a qualification or a training. And I will make that good, Malad, because it is provided in the rules and there is one judgment of your lordship. Let me repeat this, Malad. I wish to read it with your lordship permission again. Does not have adequate institutions. So this is the legislative.
There are three words used.
Yes, Malad.
Adequate institutions offering
Courses or training.
or training in teacher education. Two,
Or teachers possessing minimal qualification as laid down under subsection 1 are not available in sufficient number. The central government may, if it deemed necessary by notification, relax the minimum qualification requirement for appointment of teacher, but for such period not exceeding 5 years as may be specified in that
this is
notification.
one of the qualification prescribed.
One of the qualification prescribed is, my lord, they are
It is the prescribed qualification or not? Then how do you say it is not a qualification?
no, my lord, the qualification and a course.
We can understand.
Malad, kindly up page 11 of the
Just-
notification.
Mr. Marinder Singh, we are not that much, we want to understand the issue. Your emphasis is where a state does not have adequate institution offering courses, one part,
In teacher education.
please.
In teacher education.
Just please kindly, go separately. Where a state does not have adequate institution offering courses or training in teacher education or teachers possessing minimum qualification as government may, if it deems necessary. So then this is all three adequate institutions. This is one, here it should be a comma. It should be a comma.
Later proceed on that basis.
All right, it should be a comma, then come to the point, offering courses or training in teacher education or teachers possessing minimum qualification. Then as laid down.
May I respond, my lord, straight away with.
So this is like this, we
with
have to read
utmost-
like this.
Lord, with utmost respect, there would not be a comma, my lord, with utmost humility. Why? For the reason why.
No, it is just
I'm, my lord,
for understanding,
I'm
nothing, not for humanity or this is not.
I'm
like that,
responding.
not like that.
My lord, I'm
It's for
responding.
only interaction.
Yes, for only in that spirit, my lord, I'm responding. The state is not having something which is that educational institution it does not have. Educational institution is a common word both for course, that is, state does not have adequate institutions for imparting education, offering courses in the teacher's education, that is number one. Number
It is
two,
not in the or is there before that.
I'm answering that one. Please read it again. Adequate institutions
Offering
offering
courses,
courses. I stop here.
one, huh?
I stop here.
Yes.
And now read it again.
Not and thereafter or is there.
Malad, I'm coming to that, Malad. Just for me.
You are using and.
No, Malad, now kindly see the first. I'm only categorizing in two. What is the meaning of this?
Yes.
State does not have adequate institution is common.
Yes, comma.
Right, Malad?
Hmm.
Adequate institutions for what purpose?
Yes.
Two different classes. One is offering courses. So state does not have adequate institutions who would offer courses in what? That courses are in the line below teacher's education. It's not the science course or a medicine course. It is teacher education.
Why the word or is used?
I'm coming to that or.
Yes, come to
Then,
that.
Malad, there are institutions who also offer training. They are not.
Too far-fetched
No,
now.
Malad, now kindly utmost respect, Malad. The does not have adequate.
You want this section to be rewritten,
No, Malad, I'm not doing that.
language.
I'm not doing that at all. I'm only saying, Malad, that is not a part of this particular provision. I'll show to your lordships how. If your lordship may have, Malad, it is so, Malad, because the scheme, statutory scheme is that which has also stood accepted in the rules. The 2019 TET rules specific.
All right, we take it as you are saying.
Yes, my lord.
We take as you are saying.
Correct, my lord.
Please go ahead.
Now, my lord,
Please
if,
go ahead. I will put a question
Yeah.
then after
yes,
completion
my
of
lord.
your answer.
Now, what is the sequitur of that is, if a state does not have institutions who can offer courses in the teacher education, number one, or does not possess adequate number of institutions who offer.
Your intent is offer courses or training be read conjointly. Either courses,
Both.
offer courses or training, then in teacher education.
Well, teacher education is common.
So teacher education, what do you mean by teacher
In
education?
teacher education, there are offering courses, and also for the purpose of teacher education, there is a training separately. So there are institutions who offer.
So this doesn't cover PET. You want to say this?
PET doesn't fall under it.
You want to say?
Yes, well, that's why respectful submission.
We can understand your
Let
argument.
me repeat, well, let me repeat for my benefit. Let me
No, no,
repeat.
certainly.
Lord, the first thing is which your lordships have to see is the legislative acceptance that whatever scenario is existing in the country, there are states where when you lay down the NCT standards and the B.Ed courses, the adequate institution, which adequate institution would mean those who are recognized by that centralized authority.
Yeah, that is it.
To impart that course or a training. Therefore, if that is the situation, you have to meet the requirement of the state for primary education. So therefore, for a maximum period of 5 years, the relaxation for those conditions can be granted, but that authority is vested in the central government. Now, my respectful submission is, my lord, if your lordship now come to, my lord, that additional documents, page 11, where your lordship has seen the advertisement. Just have a look at that, my lord.
No, we'll go to that. Here the complete the rule.
I'm only
That's
on
fine.
that. Only on that, I want to take a strength
All
from
right.
that argument.
Right.
Just keep it with that, my lord, section 23, keep it with page 11 of the additional document where your lordship has seen the advertisement. Page 10, it starts, my lord, page 10.
Yes.
This is that notification of 23rd of August 2010, my lord. Which,
Yes.
I'm sorry, my lord, this is not advertisement. This is that
This is the-
NCT rules, my lord, of notification of 23rd of August 2000.
Prescribing qualification.
That
for
is
teachers.
coming
I'm-
to
I'm
page
coming-
35.
I'm coming to that, my lord. Yes. Page 10. Minimum qualifications. Right, my lord?
Page
Page 10, my lord.
10.
Minimum qualification number 1.
Yes.
Then, my lord, your lordship will see small Roman I classes from 1st to 5th.
Yes.
Now, please see the first A. Senior secondary for or its equivalent with at least 50% marks and 2-year diploma in elementary education, whatever name known. Right, my lord? This is 1. 2, or. Senior secondary or its equivalent with at least 45% marks and 2-year diploma in elementary education, whatever name known, in accordance with the NCT recognition norms and procedure regulation. So there, my lord, your lordships appreciate, my lord, the recognition concept by the centralized authority, the regulatory authority, NCT institution that is recognized by them. Then, my lord, senior secondary for its equivalent with at least 50% marks and 4-year bachelor of elementary education, senior secondary or its equivalent with at least 50% marks and 2-year diploma in education, special education, and so or is gone. Or is the options in the educational qualification of a course. TET is neither a course nor a training.
Yes, please.
It is, I'm sorry.
Yes, please. Kindly read the rule again.
Senior second, I'm starting
Minimum qualification,
Minimum-
class 1 to 5.
class is 1 to 5.
Oh.
Senior secondary or its equivalent, that is 10 plus 2, my lord,
Hmm.
with at least 50% marks and 2-year diploma. My lord, your lordship know in educational, teachers for education, my lord, they are diplomas and B.Ed. Right, my lord? So one is this diploma, you must have 2 years. First of all, you have 10 plus 2 with 50%. Then you do 2-year diploma. And then, my lord, 2-year diploma. And then second choice is senior secondary, that is 10 plus 2 or its equivalent, with at least 45% marks. Supposing I have received 45% marks, I have not received 50%. And 2-year diploma in elementary in accordance with NCT recognition norm and procedure regulation. Or senior secondary, that is 12th, with at least 50% marks, and 4 years of bachelor elementary education senior secondary with at least 50% marks, and 2-year diploma in education special education. And then, my lord, it or is gone and comes.
Yes,
And now permit me to read.
yes.
My lord, 10 plus 2 is an education qualification of a course. The 2-year diploma is a course. B.Ed is a course. This is neither a course nor a training. I'll read it, my lord. Pass in teacher eligibility test to be conducted by appropriate government in accordance with the guidelines framed by NCTE. And, my lord, now read with this, which is, my lord, otherwise the position in the 2019 rules, which is in the counter affidavit. Just keep both of these documents here. Kindly see Rule 11.
Rule 11.
Rule 11 of the 2019 rules of TET. We start at page 21. There also, my lord, we have to update. There are various amendments made.
No, Mr. Maninder Singh, we can understand whether this stand have you taken ever in the High Court? Whatever you are making here,
No, my lord, TET.
or submissions.
My lord, this is not
We
an.
can-
This is not the stand taken.
My
But
lord,
let us
You are
understand.
saying that they don't have a case and you had
Mr.
to.
Maninder Singh, we can understand for the purpose of interpretation, something can be done. All right, this is one part. But at least you must have come out with a case that please listen. So far as this qualification part is concerned, whichever you are saying, that is not required, and their contention relying upon 23 would not be good because of in section 23, it doesn't specify like this.
my lord,
And even then, the government standard like this. We can understand your argument is fine.
my lord, I have understood your lordship question. Please permit me.
And you made the amendment in the rules.
I
You also understood this all is applicable.
no, my lord.
No?
My lord,
But for the amendment was required if this is not the qualification.
3(2) is to be applied. Amendment can't be made by a state government. With utmost respect.
State only made the amendment.
Because we are entitled to amend the TET rules and our recruitment rules.
All right.
My lord, I'll answer. It's a question.
All right. That also we'll see.
No, my lord, I'll
But
show-
where is that stand in the written statement?
That's what I'm trying to answer, your
So
lordship.
you never let the High Court examine any issue?
Your lordships are questions, or my lord, straight to me, which must be answered, my
No,
lord.
we are asking a question. You please go by what is your stand before the High
My
Court.
lord, I will.
First start by that.
My lord, the prayer, the relief.
No, relieve me. Please, what is your stand before the High Court? Come with your WS. Return, counter affidavit. Please come. Mr. Maninder Singh, don't go out of that.
My lord, I will.
No, we will not
I'll stick
read
to the-
read more than that.
My lord, I'll stick to the pleadings.
Please come to the pleading.
Yes.
Where this pleading is there.
Yes, let us see, my lord. For that, my lord, I have to show your lordship the writ petition, what is the
Yes.
case pleaded. Now, let us see the writ petition. We have a writ petition. Show me.
Which
Page
page?
number
Which page?
268 in the SLP paper book.
268.
It's at 268. Come to, please, my lord, your lordship, kindly come to 268.
You never argued all this. The AG conceded. That's all on his
My
sections.
lord, I am duty bound to answer every question of your lordship. my lord.
Certainly, sir. Certainly.
The AG statement followed by the subsequent rule is a matter of record, and that
You can't say matter of record.
it's recorded in the judgment.
That's there.
Yes.
But the AG never said so. Despite the reply that they don't have a case, the AG said, all right, we will consider them eligible.
Kindly see, the prayer is of CTET.
Yes, yes.
Inclusion of that CTET.
Ah.
CTET has nothing to do with 23(2). It is not claimed on the basis of 23(2).
that you have not come to that.
My lord, I'll show you
We will
what is
discuss-
the,
we
my
will
lord,
discuss that. Please let us understand your
I'll
pleadings.
see the writ and the counter
Come,
first.
come.
Let us go to the writ. I will try to find out, my lord, is there any foundation that you have no jurisdiction at all? The other
Case
side,
initially was not that.
my lord,
The case initially filed before the advertisement.
yes,
It said you are not holding any test.
because, my lord, there existed, one is not holding the test because
Yes.
tests are not held after.
And then they said you make them eligible, that's all.
Your
It's
lordship is
not
right.
before the advertisement.
2016, after 2016, unfortunately, state has not carried any TET
Whatever is
after
there.
that. The recruitment which is to take, and your lordship is absolutely right, the writ petition is filed before
Before
that.
that.
Because till that time, it is only Jtet which was making the candidates eligible.
You did not hold any recruitments from 16 onwards.
But 16, nothing has happened. 16 is frozen, my lord, your lordship
Ah.
is right. Both, my lord, for the purpose of recruitment as well as holding of a TET.
All right.
Right, my lord? Your lordship is perfectly right, my lord. When this writ petition is filed, as per the existing rule, there is a condition of Jtet to be possessed by the candidate to become eligible for any recruitment process to be held by the state for teacher. The writ petition is filed first by the candidate who are possessing CTET. They are not saying that under 23(2), CTET has to be included because that is the domain of the state. Kindly now see what is the basis of the writ petition. First, my lord, absolutely right. At page 272, the TET is not being held. Now, my lord, kindly see page 275, where reference is made to the TET of 2019. Page, my lord, 275,
75.
para 2, sub-Roman I, where, my lord, with reliance on rule 12 of TET rules, that you will hold the exam annually, is referred to, my lord.
2019, the rules were framed.
Well, your lordship, which the rules which your lordship has seen in the counter page 21, they are TET rules of 2019.
Right.
In that rules, my lord, Jtet is the TET where clause 12 of the rule says the state will conduct
Annually.
examination on regular basis annually. That has been referred to, my lord, in subclause Roman 1 of para 2, which goes up to 276 and refers to rule 12 on the top, my lord, second line. Rule 12 of the aforesaid rules.
Yes.
My lord, page 276, second line on top. Rule 12.
Yes.
Then, my lord, your lordship will see that sub-Roman 2, TET has not been held by the respondent, particularly when there is a guideline of NCT conducting teachers eligibility test to conduct a TET in every year. That letter of the, my lord, the NCT is 11 to 11, which is relied upon. Then kindly come to, my lord, then your lordships can skip. 279 bottom Roman 6.
Not that for last 6 years.
Yes, my lord. And then, my lord, if your lordship may kindly come to the recruitment rules, which is, my lord, referred to in sub-Roman 8 at 281. Which, my lord, these rules were, my lord, just here something is relevant, which, my lord, my friend had instructed me to take that as a preliminary submission, but I said, say it must discharge its owner to answer. My lord, 2012 rules were substituted by 2022 rules. Under 2012 rules of recruitment for teachers.
There is one question. Again, same thing. They filed a writ petition, pleadings are there, whatever is there before the advertisement. You were contesting that. With reply also, with argument also. All of a sudden a stand is taken that we concede their case.
That's, if your
So that means pleading or no pleading, you had conceded everything.
if the state in a given circumstances with the enabling provision and a policy, my lord, in
Not your stand.
I'm on my stand. I'm on my stand of the
You are standing, that's all right.
my stand. My lord.
Your stand is all right.
If my
But where is your stand in the reply?
I'm my lord.
Yes.
Kindly, my lord, my respectful submission is this, my lord. NCTE has taken over the field to some extent, the state's autonomy to the extent which is permissible for the primary education is not taken away. NCTE, my lord, is predominance has come. Everybody must follow that, my lord, for complying the scheme.
So standards laid down. This.
Standard laid down, right, my lord? in that laying down the standard, the central government role for exemption or concession or relaxation is not for any norm of TET. Is not for any norm of TET. It is for the states to decide whether they are permitting CTET or not.
Please come to here.
So, my lord, is the state.
Let us understand you are coming on the pleadings of the.
My lord, clause.
Then come to the pleadings
Kindly
of
come
the
to
WF.
81.
Then come to the pleadings of the WF.
I will.
Then come to your stand before the Supreme.
Yes, my lord. Supreme Court as well as, my lord, in the High Court, do we file two affidavit, original affidavit and then supplement?
We are ready to.
Yes, my lord, kindly see 281, 2022 rules of recruitment. Now, what I was explaining was something important which has not been informed to your lordships. 2012 rules had not provided for any entrance test for teachers by the state. It had not provided. You, on your qualification, some kind of a weightage used to be given, and then you would get selected. They challenged, my lord, 2022 rules, the same set of petitioners, before the Honorable High Court, that you cannot now convert this 2012 no test to a test now, test for recruitment. They filed a writ petition stood rejected, where they challenged the 2022 rules. And the same advertisement which was put in, the advertisement is challenged, the rules are challenged. Well, the High Court rejected it. 9th of September, where they wanted to rely on this petition, I'm informed, I'm instructed, I was not appearing.
No.
This Honorable Court had dismissed.
Suppose the rules of 22 was challenged. And
the advertisement is also challenged.
advertisement when issued?
July 23 advertisement.
23.
So how it can be challenged?
The
rules when it was challenged?
the rule, the 23, the advertisement is issued.
There was a separate writ for that.
Yes, my lord, by the same set of petitioner.
Maybe of that hardly makes any difference.
No, I'm so, my lord, only as
That
a
is
matter.
not making a difference.
My lord, they kindly see the prayer.
We can come to a different point.
I will, yes.
You are saying that 22 rules along with the July advertisement, it was challenged by the same set of petitioners.
Yes.
And the challenge was to the rules. What were the rules under challenge in that?
Rule 20, rules of 2022.
What was that particular rule under challenge?
You have mentioned so in your counter affidavit.
Counter, it has been mentioned.
In Supreme Court.
That they,
I can assist.
the Supreme Court.
Just no interference.
The Supreme Court order is on 9th of September.
No, that's right, but did
The
you
High Court
mention?
order.
Yes. Did you mention in your counter also
Was it mentioned?
that they filed this writ petition dismissed and the matter is pending before this court?
No, the High Court order, you must be aware. It's not there in the counter, my lord.
Leave aside. We want
Lord,
to
yes,
understand a
please.
different thing. Writ petition filed challenging the rules of 22. Which rule was under challenge? Number one.
The entire set of rules as ultra virus.
Sir, entire rules can be.
It's not there incorporated in the order.
No, we can understand
Just
what is there.
Let's have a look
And
at
then
it.
one thing,
Yes.
and the another is advertisement. So which condition of the advertisement was challenged? And
Meenakshi were appearing.
and suppose
Lords, they had challenged the entire rules and the entire advertisement on this ground that because the 2012 rules are prevailing, they should get direct appointment. They should not go through this process, which is subject matter here, saying that they should get direct appointment because they have been waiting.
Also, because under the present thing, they will have to take an examination. So previously said we have to take the examination.
And interview.
After 22 rules, they have to take an examination for appointment. They wanted to overreach the 22 rules to say that the 15 question.
what is the relevance of that even? Maybe that as per rules. At present, 22 rules are in vogue. 22 rules, as per 22 rules, whatever is read over for the purpose of qualification, for the purpose of entrance test, it is not in dispute. So once it is not in dispute, then even they have challenge for that. And whatever the decision is dismissing that petition, what may be a consequence to the present point? There may not be consequence of present point. And see, we'll look into let Mr. What is the relevance of this, Mr. Maninder? Mr. Maninder Singh, please.
Kindly see, my lord, page 281, I was showing to your lordship the two reference.
Yes, please.
For reference to 2022. Then, my lord, your lordship may kindly come.
Yes,
Para 8, my lord, that the state is not conducting TET after 2016.
all right.
And then, my lord, if your lordships may, in continuation of that, kindly see para 7, 286. 286 para 7. It is relevant to state and submit that the petition number 2 is the mother of one of the aspirant who is willing to participate in the selection process in the state but cannot do so because of the mandatory requirement of Jtet qualification, whose examination has not been conducted in 16. The petition 2 has come across several number of candidates who possess all the requisite qualification to be a part of selection process, but the state has made Jtet as mandatory. It is not being conducted state for last 7 years. And then, my lord, if your lordship may kindly come to the prayer.
Hmm.
Page 289.
Page 289.
Last 3 lines, my lord. Prayer A. For showing cause respondents, teachers eligibility test examination, the state since the year 2016, in spite of regular demand and protests of large number of affected candidates, which is not only creating chaotic situation, the law and order, but also amounting to ruining the aspirations of poor students state who are merely aspiring to participate in the process of appointment for the post of teachers, which very much requires a candidate qualified TET as mandated under the provision of the National Council for Teachers Education guidelines, as per which such examinations to be conducted on yearly basis. But unfortunately, no compliance by the state respondent, gross violation of the guideline of NCTE and the rules of 2019, my lord, which are the TET rules, where also, my lord, the stipulation is contained that you will conduct it regularly.
But if
And-
we read this in true sense and spirit,
Yes, my lord.
then these petitioners has stated that as per NCTE, under RTE, NCTE is the authority which shall prescribe minimum qualifications for the purpose. They admit this part. TET is mandated under the provisions of the National Council of the Teachers Education Guideline, as per which such examination is to be conducted on yearly basis. Like this part they are admitting for the purpose of examination because this relief relates to that holding of that examination. Now come to B.
B. For showing cause is also how they will redress the aspiration of large number of candidates available in the state of Jharkhand who have acquired all other requisite qualification for participating in the process of recruitment of teachers in the state other than having the mandatory TET qualification only because of fault and laches on the part of the respondent who have neither conducted the TET examination since 2016, nor have they taken a decision to recognize CTET qualification.
So here they say recognize CTET. Now come to next.
For directing the respondent to either conduct the teacher's eligibility test in the light of the Jharkhand Teachers Eligibility Test Examination Rules published, notification number so and so, which mandates the state authority to conduct the TET examination every year and oblique or to consider the CTET qualified candidate worthy for participating in the selection process of the teachers in the state as per the policy of 2011. Now, my lord, this, if your lordship may kindly see, there is no argument of any 23(2). The only argument is that the NCT prescribed.
What they are asking there before the writ court, they are asking that we are aware CTET is not the qualification prescribed for the teachers test in the JTET, in the rules of 22. So please, number one, hold the regular test as per 2019 rules. Number two, or CTET may be
Included for eligibility.
included for eligibility.
Correct, my lord.
Now, for that purpose, we have to look into what is the answer of the state.
Surely, my lord. But what I am
Like-
respecting, yes, my lord, your lordship may kindly come to the counter
Counter.
295.
Yes, please. please, where we have to look into?
Malad 295 it starts.
Yes, please.
Kindly come to 297 bottom para 7. Where Malad the.
You have taken it as a public interest litigation. So you said it is an instant public interest litigation was filed for the following reliefs.
Yes,
All right, then you have referred to the reliefs.
yes, Malad.
Then you have started answering so and so. That is stated and submitted
At
without para-wise reply.
301 Malad.
Yes.
1. Kindly see para 10.
No, first 9. You recognize RTE Act.
No, Malad, that RTI nobody can run away. That.
We are only referring, Mr. Maninder Singh, they are not saying
Yes,
anything.
sir, RT Act is.
So what appointment as a teacher in any of the school referred in clause N
Yes,
of section 2 of RTE Act,
Malad.
is he or she should possess a teacher's eligibility test,
Yes.
which will be conducted by appropriate government in accordance with the guidelines framed by
Correct.
NCT.
So that is.
So for the answer one part, this is next.
10.
Come to 10.
It is stated that therefore the respondent is serious in implementing the provision of RT in its true spirit and letter, for which various consultations carried out by the respondent with different stakeholders. Better implementation of TET objective after looking to geographical and regional needs and requirements such as various languages, tribal cultures, Hindi language speaking, population difficulty before conducting a fresh TET examination is the state of Jharkhand.
Yes.
Para 11, that the COVID-19, my lord, your lordships can skip.
All right.
12. So far, CET exam is concerned, center teacher eligibility test is conducted for determining the eligibility of the candidate for post of 1 to 8 in central government schools such as NVS, KVS, and other school which does not fulfill the needs and requirement of the state, regional languages, and other local needs, and whether to consider CET qualification as equivalent to Jtet in the matter of policy decision. Then, my lord, your lordship, you can come to para 15.
Yes.
Respondent in the process to bring necessary amendments in the JTET exam to bring it on the quality and standard of CTET level. It's most humbly submitted that the respondents are going to bring some necessary amendments in the JTET rules, which is under.
Rule kindly para 13 is also. Relevant.
Yes, my lord, 13 I read.
It is most humbly and respectfully submitted.
The respondent state is in the process of framing a rules for conducting fresh TET examination in the state of Jharkhand, which is under process, and due to which much time has passed for conducting TET examination in the state of Jharkhand. Then, my lord, 14, once the rules will be framed, it will be sent for cabinet.
Then 15.
15, the respondent in the process to bring some necessary amendments in the JTET to bring it on the quality of CET test. And, my lord, it's most humbly and submitted that the respondent going to bring some necessary amendment which are under process. Stated that the circumstances prayers are misconceived. So, my lord, what the state response?
It's only TET, about TET you are telling.
Only about TET, because the prayer is only for TET. Conduct of TET or CET be permitted.
Eligibility.
All right.
It's a eligibility test.
All right. Please go ahead.
My lord, then.
And one thing you admit here, para 15.
Yes.
The respondent is under process to bring some necessary amendments in JTT exam to bring it on quality and standard of CTT. That shows that your standard is lower.
No, what happens is.
That's what you are saying.
Lord, the standard of CTET for central schools and other schools
Is higher.
does not necessarily mean, my lord, the standard in the state may be lower. But yes,
This is what you are saying.
it's always an aspiration, my lord, that you must also be in that my lord, pedestal where you can say, I am as good as anybody else. But that does not mean, my lord, that I am not meeting the requirement of minimum.
For that you have to accept that somebody is above.
Your stand is, it indicates that further respondent is under process.
Yes.
Necessary amendment in JTET exam
Yes, my lord.
to bring it
Yes, my lord.
on the quality and standard of CTET level.
Correct, my lord.
What does it mean?
My lord,
Your exam and the rules are not at par to the CTET. So you want to brought it to the CTET
your
level.
lordship may also read it with para 12, my lord.
Yes.
Read.
12, if your lordship may permit.
Yes, read.
That so far as CET exam is concerned, CET test is conducted for determining the eligibility for teachers for classes 1 to 8 in the central government schools such as so and other schools, etc., which does not fulfill the needs and requirements of state, regional language, and other local needs, and whether to consider CET qualification as equivalent to TET in the matter of policy decision, which, my lord, is the clause 10 of NCTE. And clause 10 made it only enabling for.
Please go ahead. This is not allowed. Go
No,
ahead.
clause 10, I have to come.
We'll consider, we will not look into on that. Come, go ahead.
Yes, my lord. So this is the reply which is given, my lord.
No, please go further.
Yes.
Further reply.
Para 16.
Yes.
It is submitted that the respondents are going to bring some necessary amendments in the JTT rule which is under process.
So this is, you said this is misconceived. Then rejoinder affidavit.
Please no reply to the.
Third here, anything about that point that the CTET must be made applicable or not? You said, merely said one line, it's a policy decision.
No, I am saying something else, my lord.
So this is the first counter affidavit.
Yes, my lord. Of
Which
course.
is another counter affidavit.
Yes, my lord. Let me show the second counter and then make my submission.
Yes, please.
Supplementary affidavit. 300 and my lord 15.
315,
Yes.
supplementary counter affidavit.
Yes. ma'am. It starts at my lord 314. And
Yes.
then my lord, your lordship may kindly see. Para 5. At 317.
No, there is some order of the court.
There was an order of 15/7, 25/7,
The petitions were
Which is that order?
25/7 order.
The import of that also.
25/7 order. Just, that is one, my lord, your lordship seen yesterday that the writ petitions were filed before the advert.
No, that's
You
right.
want to see
Yes.
this order of 25/7?
Yes, yes, I'll just give it to your lordship, my lord, that order.
Where is this order? Page 58 of
The counter affidavit.
Supreme Court counter affidavit. Supreme Court counter affidavit दीजिए. Supreme Court का counter affidavit.
Page 15, 58, my lord, I'm sorry, page 58. Same, my lord, where your lordship had seen that rules, same volume. In the course of hearing, at page 58, my lord, if your lordships have got it.
Yes.
In course of hearing, learned senior counsel, she is so and so appearing for the petitioner in the lead case, would draw the attention of court to clause 10 of the guideline for conducting TET, which is provided at subclause school. I'm sorry, my lord, your lordship, this is my statement. May I read it, one?
Yes, please.
In course of hearing, learned senior counsel appearing for the petition in the lead case would draw the attention of the court to clause 10 of the guidelines for conducting TET, wherein it is provided at subclause B that a school referred to in subclause 1 and subclause 2 mentioned therein may also consider eligibility of a candidate who has obtained TET certificate awarded by another state UT with legislature in case a state government UT with legislature decides not to conduct a TET school at 1 and 2 in the state UT would consider the TET conducted by the central government. We are of the opinion the state government is genuinely creating a number of posts for which state TET examination required to be conducted, which has not been held at least for last 9 years. The examination was held in 16. Then it should take into consideration the said provision. We advise the state to file a short affidavit stating whether they intend to allow these candidates who have obtained TET certificate from the central government.
Now read your counter.
Yes, Lord. Now kindly see, come to para 5, 317. 317, para 5.
Yes, please.
The reference is made to this order, my lord. So your lordships can skip para 5, para 6. It is submitted that before going into the query, it is necessary to bring a factual aspect for proper adjudication. One of the essential qualification of person to be appointed teacher is referred to in so and so is RT Act is that he should pass the eligibility test of TET, which will be conducted by the appropriate government in accordance with the guidelines framed by the NCT. It is stated and submitted that state of Jharkhand is intending to implement the Jharkhand TET objectives in consonance of the geographical, same thing, Lord, with regional need requirements such as various languages tribal languages, culture and Hindi language speaking population within the state of Jharkhand. It is most humbly submitted that the central teacher eligibility test hereinafter referred to is basically concerned is conducted for determining the eligibility of candidate for teacher post class 1 to 8 in the central government school such as NVS and KVS and other schools. It is stated that the state of Jharkhand has formulated its own teachers eligibility test rules of 2019 dated 4/10/19, which apart from math, science, social studies teacher stipulation for language teachers, the rules further prescribe for eligibility of teachers imparting education of regional language, other local tribal languages for the preservation of culture, needs and diversities of the state. It is stated that Jharkhand Teachers Eligibility Test Rule 19 prescribe for different eligibility criteria with respect to appointment of language teachers who are required to have qualification, at least one local language out of various local and tribal languages spoken in the state. That also, my lord, would answer your lordship. One, either the regional or tribal, my lord.
That the rules provide.
Yes, that is stated that Jharkhand Council of Education Research and Training, Ranchi, is responsible for performing the important function of promotion of education research, improvement of educational technique, practices and such, finding development, curriculum is in instructional and exemplar material method of teaching, techniques of evaluation, teaching data. It is stated that the Jharkhand Council of Education Research and Training, apart from aforesaid activities, publish and distribute books for regional and tribal languages free of cost, etc. Further stated that there are enough numbers of JTT qualified candidates within the state and hence allowing CTT qualified teachers in the vacancies of the state and school with cause prejudice. Stated that there can be no doubt about the fact that the ultimate beneficiary of the recruitment process would be a large number of children within the state who would suffer if there is undue delay in the appointment of teachers. However, the state is at liberty to set the qualification, particularly when these qualifications are in accordance with the statutory guidelines framed by NCT. Please mark this sentence, my lord, that it would be for the state to decide which, my lord, test is to be permitted, because that is the domain of the state, and that is also, my lord, recognized and acknowledged in the NCT guidelines. It is further stated that petitions contain and place reliance on clause 10B of the guideline for conducting teachers eligibility test, which provides that TET conducted by state government with legislature shall apply to a school.
Hello.
You complete this, then we'll go.
Yes. School of the state government duty with legislature and local authority referred to in subclause 1 of clause N of section 2 and a school referred to in subclause 1 of clause N of section 2 of RTR. The guidelines further provide that a school at 1 or 2 may also consider eligibility of a candidate who has obtained TET certificate awarded by another state UT with legislature. In case a state UT with legislature decide not to conduct a test, a school at 1 and 2 in the state UT would consider the TET conducted by the state government. That it is further stated central TET qualified candidate qualifying TET by another state can only be considered for a state-run school when the particular state government has decided not to conduct its own test. Submitted that it's not the case of the state government has decided not to conduct the JTET, and these circumstances, state government is not bound to consider central TET or a candidate qualifying TET by another state UT as eligible qualification. The CT qualified candidate can be made eligible in a given contingency where the state government is not conducting TET. But when the contingency does not exist, there is no occasion to make central TET candidate eligible or to allow those candidates who obtain TET certificate from central government or any other state. This is submitted that there has been certain contingency due to which regular JT examination could not be conducted regularly, and hence the state is intending to allow age relaxation to the candidate for upcoming vacancies. Moreover, it is also intended to conduct JET examination before start of fresh recruitment of teachers within the state. Stated that issue whether to consider CET or TET from is a matter of policy decision of the state government. I have read and understood. So, but that is.
But before this date, the advertisement had been issued.
Before this date of filing this affidavit. This
is 14th August.
14th of August.
July advertisement was there.
Advertisement is issued on 9th of July. Yes, your lordship is right. I'll come.
We'll come back.
Yes.